Tēnā koutou, no mai, haere mai. Hello and welcome to Lane Neave's webinar on sick leave and medical incapacity. Thank you for your patience this morning. So I'm Maria Green and I'm a special counsel on Lane Neave's employment team, and I'm based in the Christchurch office. Lane Neave is a full service law firm. We have offices in Auckland, Wellington, Christchurch and Queenstown. So I'm going to be asking questions of our panel to learn more about managing absent, sick and injured employees and gain some practical tips in a space that can be difficult to navigate. I feel like this is always a useful topic. While it would be great for businesses if employees could work like robots and never get sick or injured, unfortunately that's not the case. Unique issues with illnesses and injuries crop up often, and no two situations are the same. So on our panel, we have Andrew Shaw, who heads up our Christchurch employment team, and he's also our managing partner. Next, we have Andy Bell, who heads up our Wellington team. And finally, we have Gwen Drewitt, who's a special counsel in our Christchurch team. So if there's time at the end, we're happy to take further questions. So please feel free to use the chat function and enter your questions in there. Okay, we'll just start off. So Andrew, what's the difference between absenteeism and medical incapacity?
Karen, thank you, Maria. So absenteeism is when the employee is away from work without good reason. And that could be anything from stuck overseas and they can't get a flight home, to simply not wanting to come to work, or they could be arrested in jail. Medical incapacity is somewhat different. That's where the employee has a diagnosed condition and they can't come to work, typically on a medical certificate, because they're not fit to work and that their health and safety concern if they did come to work.
Right, so yeah, when we talk about medical incapacity in this webinar, we're talking about that those long-term issues, whereas absenteeism could be frequently on sick leave or patches of sick leave and then they come back to work. So there's just that distinction there before we get started. Thanks, Andrew. So Gwen, what are the rules around requesting a medical certificate?
So look, you can request a medical certificate under the Holidays Act if an employee is going to be absent for 3 or more consecutive days. The interesting thing there is that those days don't need to be working days. So it could be someone is unwell on a Friday and then they're going to be unwell on the Saturday and Sunday. You could request a medical certificate in that situation. You can ask an employee for a medical certificate within the first 3 days, but in that situation you need to get in quickly and let the employee know that you would like them to obtain a medical certificate, and you also need to meet their reasonable costs. So typically that would be meeting the cost of the doctor's charge for providing the certificate, but we have seen situations where an employee may need to travel quite far if they live rurally, and in those situations it would probably be reasonable to meet the cost of their travel as well.
I see. So Andy, what happens if the medical certificate has very little information on it?
Yeah, thanks, Maria. I think everybody watching is probably familiar with those kinds of medical certificates. They tend to turn up, I think, yeah, the standard wording seems to be has been seen by me unfit by work just today. And of course that really does nothing for you if you're the employer and you're trying to get to the bottom of things. So you definitely can ask for more detail, and there's a way that I do it that I'll explain. And at the risk of destroying the illusion that I'm answering spontaneously, I'm going to work from a standard that's available online, and what that is it's the council's standard, and it's a practice note to GPs, and it sets out what they should be doing when they issue a medical certificate. So what I do is I tend to write to the GP with a list of questions, and I attach the practice note back to the list of questions. So I'm not sure that necessarily makes me that popular with doctors, but they generally begrudgingly answer all the questions. I had one the other day, and I got a rather sharp note back from the doctor that told me that he was on holiday, but the questions were answered a short time later, and I think from his tone he must have appreciated my interference with his holiday. I think what the practice note does is it's really useful from the perspective that it tells the doctors up front what they can have in the certificate and what they shouldn't. And the general rule is it's geared around health and safety. And what the note says is that they need to say what the patient can do, what their limitations are, what might be unsafe for them to do, and a timeline. The other really useful thing that it says is if it is requested from the employer, it's about an issue that could affect that employee's safety in the workplace or somebody else's safety associated with the workplace, then they should consult with the patient and advise a diagnosis and things at work that might be contributing to that diagnosis. So really, it just sets it all out, so it's there in front of the medical practitioner. And I think, in my experience, I just get much better answers when I use it, even though I suspect that it is making me slightly unpopular with the medical fraternity and when I send it to them, particularly because the second paragraph of the practice note cautions them about disciplinary consequences if they complete a medical certificate ineffectively. So, look, if anybody wants a copy of that, I think Maria's got one, and I've got one, and if you put in the comments, we can get it. If you wish to endear yourself to the profession as well, then we can get that out to you.
That's a really good tip, Andy. I think I'll actually use that myself. And yeah, we're happy that we can put the link on when we send out the recording of the actual webinar. We could do that to participants because that could be quite useful for a number of people. Gwen, can we turn to you now, please? Can you ask for can you ask for a medical certificate to prove that an employee is well enough to come back to work after a period of illness or injury?
Well, interestingly, yes, you can, but and that right is contained within the Holidays Act, I suppose, because the Act governs sick leave. But I would expect to find it in the Health and Safety at Work Act. So Section 68 of the Holidays Act does enable an employer to require an employee to satisfy them effectively that there are no health and safety or hygiene reasons that would prevent them from returning to work. So this is a tool that we quite often employ with perhaps employees who have shown mental distress, or they behave they're behaving strangely in the workplace, or if they come into work and they're still complaining about a sore back or something, and we're concerned about them injuring themselves further. Now, there is some debate out there, because what I need to be clear on is that Section 68 of the Holidays Act says that you can only make those requests if you have the legal authority to so require. And so my view is that legal authority probably comes from the Health and Safety at Work Act. Some commentators would say, well, no, you've got the right under an employment agreement to request a medical certificate to satisfy you that they're well enough to return to work. That's enough. I don't know whether Andrew, Andy, Maria, you've got any views on that, but I think it's not necessarily settled law in terms of that right to request, but it is a useful tool.
Yeah, my view is health and safety must overrule other employment-related legislation, because as a PCBU, you've got to ensure the health and safety, not just of your workers, but anybody in your workplace. So the wording is, are you legally authorised to ask for that? I would suggest that as a PCBU, you are legally authorised. But I think equally, If you have a contract between the parties by way of an employment agreement, you again have legal authorization there to ask that they can prove that they are well enough to come to work for both health and safety, but also for hygiene reasons.
Yeah, so it does certainly help, I think, if there is a clause in the contract that does cover off that scenario, just so it's very clear. Yes. Andrew, what happens if an employee can't get an appointment with their doctor anytime soon?
So this is a real issue, especially in more remote areas or even some of the larger cities where you have some real strain on the medical system. I don't think you can criticise the employee for not being able to get that. If the employee is slack or not using all due diligence to try and get a medical certificate, then you can criticise them. But if the doctors are simply saying, I can't see you for a week or whatever, I think you can't criticise the employee. You can't force an employee to see any particular doctor. So, for example, if an employee came to you and said, look, my usual doctor's on holiday for 3 weeks, I've got to wait for 3 weeks before I see them, could you then say to them, or could you see another doctor within that practice? And I don't think you can force the employee to do that, but it gets a little unreasonable because in 3 weeks' time, whatever complaint the employee has, if it is a short-term matter, will be long gone. So it's irrelevant to seeing the doctor. So it's a real issue. Employees will often use that in remote areas or if their particular doctor's away. I don't think you can force any person to see any particular doctor. They must see their own doctor if that's their choice.
Could one way around just to test whether that actually is a genuine thing would be to contact the doctor's surgery directly and just say, look, what's your availability? To just get the sense of whether they are genuinely that busy. And that could be a way if you're trying to, if you suspect the employee is just using that as potentially an excuse, but it's actually not in reality. That could be a way to do it. Or even saying, I suppose, to the employee, hey, look, thanks for that. We're just going to double check the availability with your doctor's surgery to see if that's the case or what have you.
Let's go back to Andy's view of annoying doctors. So suddenly Lane Neave by the medical system because Andy's querying them on their prognosis, and now Maria's querying them on whether they're available. But yeah, look, it is an option that if you really have genuine concerns about whether they're taking a step with their doctor. Look, I would suggest in New Zealand that your doctor, if they're not sick or on holiday, should be available within a reasonable period of time of a couple of days. I might be unrealistic in some areas, but yeah, I don't think weeks is something that you suffer in New Zealand, certainly in most areas.
Andrew, I think you clearly haven't been to the doctor for a while, because I would say it probably takes a week, depending on when you are, to get into your doctor's surgery. So I think realistically, especially in Christchurch, depending on where you live, there'd have to be some understanding that actually it is going to take them a while, unless they can send a medical certificate out without seeing them or doing a Zoom consultation. But yeah, I think it's becoming more and more of an issue.
Yeah, and I think that's the answer though, isn't it? It's not physically seeing the doctor. If it's more urgent, you can have a telephone or a Zoom conversation with them. So for me, this is a country where you should be able to see a medical practitioner. If it's an emergency, 24-hour surgery or the hospital, again, there will be delays of hours, but there won't be a delay of a week. If it's just an injury that can wait, a Zoom conversation or a telephone conversation. And these are things you can test with the employee.
Andy, can you just talk to us a little bit more around health and safety concerns and what you can do if you do have those health and safety concerns?
Yeah, and I think the listeners would have probably gleaned that health and safety really is the nub of everything in this area, and really it's the obligation comes from the Health and Safety at Work Act, and it is that if you're a PCB or in charge of a business or undertaking, you've got some fairly strong obligations on you, and that's to take all reasonably practicable steps to keep people safe in the workplace. So, and the way that that's generally field is that it to trump everything, and the reason for that, in my view, is because we're using a test that is a reasonableness test, and that's the measuring stick of all those actions. And what that measuring stick asks is, was that course of action reasonable in circumstances? And what you're balancing is that test with your obligations under the health and safety of work test. So generally, if you think somebody is operating in a way that's unsafe, your obligations under the health and safety of work act mean that you can take, it's quite permissive, the things you can do. And in emergency situations, you know, you're justified in taking pretty strong steps to avoid that harm. If you need to change what someone's doing, stand them down because it looks like they're working unsafely or they're injured and that could cause somebody else an injury, you're justified in taking relatively strong initial steps. But I think what you also have to bear in mind when looking at that reasonableness test is that you have to respond in a way that's going to meet that test, and that's where getting medical information and medical reports comes in. So if you think someone's working unsafely because of an injury, it's the next step is you take the immediate step to prevent things going wrong and keep everybody safe, but then you've got to follow up by examining it properly, and that often entails getting a specialist view on what the person can do and what they can't do, and you take that view and you use it either to tailor what that employee is doing, or in some circumstances it actually does justify saying to them, I just don't think you can work safely and maybe we have to end this role for you. So attached to all of that is rather onerous procedural requirements as well, because it's a situation where you have to work with the employee, and it has to be a consultative process. So the procedural overlap requires a lot of care as well.
Certainly, I've had some experience with that where someone was operating quite heavy machinery and they were concerned about the employee's cognitive abilities, that it might have been the start of early onset dementia or something of that nature. And it was certainly like there was a clear and present risk of danger if he was to continue in that role even an hour longer kind of thing without looking into that further. So we had to look at like some employment agreements in terms of their suspension clauses allow when there's certain health and safety concerns to talk about suspending to sort of alleviate that short-term risk and then go from there in terms of sensitively talking to the employee, especially in that situation where it was more mental cognitive abilities, but certainly a difficult issue to deal with. But as you say, with those health and safety obligations, you've certainly you've got to take steps, and you're responsible at the end of the day as the employer. And perhaps if you let things go on without addressing them and then something was to happen, then whether you'd be prosecuted by WorkSafe in hindsight, there's certainly that risk there if you knowingly let something continue and then something terrible was to happen. But yes, okay.
It's so hard to criticise someone who is working to keep somebody safe. To say that that's an unreasonable position is a real stretch. So I think if you're trying to keep people safe in their employment, it's very hard to criticise that as unreasonable.
Yeah, and look, there's also ACC conditions or concerns to be worried about. If you're an accredited employer and you have somebody with a short-term injury, it's better to have them off and fully rehabilitated before they come back to work. Because if it becomes a long-term injury, that's on your pay book because you're covering that as an accredited employer. And even for not accredited employers, your ACC record will be damaged and your loading may be impacted because of the number of long-term injuries. So it's better to not have people at work when they're not ready, both from health and safety and ACC perspective.
Right. Andrew, what can you do if you think your employee's sick leave is not genuine?
So under the Act, the Holidays Act, and again, it's a stupidly named Act because I don't think when you're on sick leave, you call it a holiday.
No.
You are obviously entitled to seek a medical certificate after 3 days, but you are also entitled within 3 days. It doesn't talk about genuineness, but that's the test we apply. There's two things you've got to do. One, go to the employer as soon as possible and say to them, look, I'd like you to get a medical certificate. And secondly, you have to pay for it. And the cost of going to a doctor is quite significant for some employees. So the employer paying for it is required under the Act, and it's a help to them. As I say, there's no requirement for genuineness in terms of your argument under the Act. I think we apply genuineness into it. So within 3 days, I don't believe you've got a genuine sickness. I'll pay for you to go see a doctor, and you do it as soon as possible. You're entitled to do that. You know, if an employee says they're sick and then suddenly see on Facebook they're having a great time down at the beach or off at the movies or whatever, mountain biking, etc., you have a real concern, then you can ask for a medical certificate. The problem being is, will a doctor truly say this person's not sick when a lot of it comes back to self-reporting?
That kind of ties in quite well. So, do you have to be bedridden to be legitimately on sick leave?
No, not at all. No. And it's really interesting. I had a case once where an employee was on sick leave and she was also part-time doing some physiotherapy work. And so she did some physiotherapy work while she's on sick leave. And the employer had a concern with that, but we showed evidence that in her doing physiotherapy work, it assisted with her medical condition at that time. So you certainly don't have to be bedridden, and you don't have to be stuck at home either. But there is a limit between, if I'm sick, it doesn't mean I can mountain bike or go to the beach. There was also another famous case where an employee had severe hay fever, and he went out fishing. I think it was in the Otago Harbour, and they dismissed him because they said, "Well, you're sick with severe hay fever, and you've gone fishing." He brought medical evidence to show that the pollen was not in the harbour where he was fishing, and it was, for him, a recovery from his severe reaction to hay fever. So the court accepted that on medical evidence.
Interesting. I hadn't actually heard that case.
Yeah.
Yes.
So you can be very inventive as a sick leave employee about what you can do and why you can do it.
Yeah. I think these days, with now that we're more aware of mental health, and that stress is a legitimate reason for sick leave. There was a case I come across where there was a man who had recently lost his father, and he was quite stressed and had taken sick leave, and then but he was on the golf course for 3 days, and so the employer looked to terminate him to say, well, look, you're not even bedridden, you're not genuinely sick. And he could legitimately say, well, look, my wife sent me off to just go and play some golf because I really needed to decompress and I was really stressed out, and that really helped. And that was found to be actually a legitimate reason to be on sick leave. Yes, so we're seeing more of that. It's not that old-fashioned, like you should be in bed. Yeah, it might be for mental health reasons. Yes.
Yeah, I mean, if I was on sick leave for stress, I'd be down at the pub with some friends having a couple of drinks. And does that mean that I'm not sick? I don't know. I'd certainly be enjoying myself, but and that could be part of my recovery.
Andy, can you talk to us about some case studies where someone was terminated legitimately for not being genuine with their sick leave or abusing their sick leave, shall we say?
Yes, I can, Maria. I've got one here. It's the tale of Mr. Taiapa, and one of the runangas is who he worked for. And it's a little bit of a lesson in probably stretching things a little bit too far. So Mr. Taiapa requested 5 days leave without pay to attend a waka ama tournament. And he was needed to work some of that. So the employer actually said, well, we can give you the Thursday and the Friday and have unpaid leave for that, but your Monday through Wednesday, we need you back. We'll compromise with you. You can have this, but you can't have it. So partway through, I think it might have been Friday, don't quote me on that, Mr. Taiapa went home saying that he had injured his calf muscle. Monday rolls round when he was required to be at work, and he wasn't. He maintained that he was sick, but some Facebook footage revealed him at the said Waka Ama tournament in the grandstands, looking like he was having a good time. The employer got wind of that and understandably had some issues and wanted to speak with Mr. Taiapa. Mr. Taiapa attended the disciplinary meeting, and he wouldn't really tell the employer anything about the injury, and was quite evasive in that meeting. So when that came before the employment court, they said actually this dismissal was justified. There's a really interesting remark there too. He did actually get a medical certificate, but it was retrospective to cover the time. And I think that's why he took the challenge as far as he did, I would say, because he thought, well, I've got this medical certificate, but the court looked at it in totality and said that the dismissal was justified. So the one last thing I would note about this matter is that in terms, going back to my practice note, what it does say is when a doctor sees someone, the medical certificate needs to distinguish between what they self-reported and what the doctor actually observed. So that can be quite an important distinction if you're challenging a medical certificate before the court. The other thing that it has to do is it has to say, if it's a retrospective certificate, it has to say that as well. So even though they've got the medical certificate, that doesn't need to be the end of the matter, because you can look at those couple of matters to successfully challenge whether that person was on an authentic sick leave or not. So a bit of a cautionary tale. I think if Mr. Taiapa would do that again, yeah, you need to Lane, either say you're sick or ask for the leave without pay. Don't do both. I think it's a little bit obvious in the end.
100%, yeah. And it does just demonstrate that, yes, if someone is abusing their sick leave, you can go through a disciplinary process. And there have been instances where it only takes one time that they've abused it and been misleading to really, which can justify termination on the basis that the trust and confidence you have in that employee is gone, because they're saying, look, I'm sick, but I still, I'm getting paid on sick leave. But actually, if you're not, then that can go to the heart of them, the employment relationship. There's another case I'm aware of where an employee, they took actually unpaid sick leave to do an overseas trip. And that was obviously not genuine sick leave, and they were justifiably dismissed. So there certainly are there's actions you can take, and so I know it can be difficult, and that's where you call us to discuss whether what options there are to address those issues if you're having a problem with an employee. Well, thanks for that, Andy.
Maria, if you do take sick leave to go to a sporting event, like a gentleman I once dealt with in a rural area where he went to a bowls competition, make sure you don't win it, because you'll be on the front page of the paper the next day. So you've got to be very careful about what you do on sick leave.
Don't win it, don't put it on Facebook.
Gwen, can we talk about what are the things you need to think about? We'll turn now to medical incapacity. What are the things you need to think about as a starting point? And is medical incapacity the same as medical retirement?
Good question. So, no, they're not the same thing. Medical incapacity is a situation where you are considering an employee's who is either injured or unwell to the extent that they can't perform their role, and the courts say that in those circumstances you can consider terminating their employment on the grounds of medical incapacity, but there are certain hurdles that need to be met, and no one case is the same, and I'm sure you'll have lots of questions around that. But medical retirement, in my experience, it's more of a contractual concept. You find it a lot in old collective employment agreements or old individual employment agreements, in some policies where an employer recognises that an employee can be retired medically, quite often in return for a decent payment. So you might find that some employees reach the end of their career and are looking for excuses to be, or reasons to be medically retired, because it means they leave with a decent package or ex gratia payment. So conditions like sleep apnea and that kind of thing can sometimes trigger a medical retirement, and an employee might retire from a role. It doesn't necessarily mean that they won't pop up somewhere else, because it's quite a different concept. So quite different processes, although you can start a medical incapacity process and end up agreeing in some occasions that an employee will qualify for retirement. I have seen that happen, but it would only be by negotiation with the employee.
So, Andy, do you need to consult with employees over termination for medical incapacity?
Yeah, absolutely, Maria. I think I touched on it a little bit before. I think for me, the way that I understand it, that the consultation is pretty fundamental in all processes in employment law, and it all stems back to what good faith entails and the test for reasonableness, what is reasonable in all the circumstances. So particularly with a medical requirement, because, and I put it almost in the same class as redundancy, because it's not really the fault of the employee that they've got the issue. So it needs to be handled with a higher level of sensitivity than typically you would for something like a misconduct issue. So it's very, the level of consultation that surrounds it is quite rigorous. And I think beyond that, there's an expectation when the authorities are assessing the employer's actions, whether they were reasonable or not, to handle it with a high degree of sensitivity as well. So I'd say absolutely.
Andrew, before you decide to terminate someone for medical incapacity, what exactly does the employer need to consider?
Well, the starting point is the employment agreement. Is there any provisions within that agreement as to how you look at termination on this basis? You then go to your policies. You may have a policy for termination. In the absence of those two, or even if you have them, you consider how much sick leave is available to the employee. If they've got sick leave available and you don't have a unlimited sick leave policy, clearly they're not that unwell in terms of being away from work. I think you also look at what the current diagnosis is and what the prognosis is. I might be sick for a couple of months, but I'm going to get better and then be able to work from there, or I might be sick for a couple of months and then there's uncertain prognosis. I'd also look at whether you can retrain, re-educate the employee, or redeploy the employee into another role. So as Andy said, it's about consultation with the employee, and that's under Section 103A of the Act, the test of justification. You're looking at every alternative option before you look to terminate their role.
Gwen, how long does someone have to be away for before the employer can consider or terminate their employment?
Well, look, if I had the answer to that, I think I would be a very popular employment lawyer, because that's the $1 million question in all of this, and we get asked it time and time again. Unfortunately, the classic answer is there is no one answer. The legal question is, has it got to a point where it's fair to cry halt? Now, in what that really means is that it's a highly factual inquiry into the matters that Andrew just discussed, but including what the employee's role is, what is their medical diagnosis, prognosis for recovery, what's the pressure on the business? Is it significant enough that you need to act now, or could you reasonably act later or leave it for a while? So there's a whole range of factors that go into determining when you can make a move. Length of service is also relevant, and my view could be controversial, please interject, but my view is that you can start making moves with an employee who's been employed with you for maybe less than 6 to 12 months at around the 2 to 3 month mark. But when I say making moves, that would be gathering information, making inquiries about when they're going to be well enough to return to work. But it really does depend on the role in question and the pressure on the business.
My view is that you can probably start making moves a little bit earlier than that, depending on the injury or illness, because sometimes it's quite evident from the start if they've been like in a car accident and they've been quite significantly injured, that you're like, look, this is clearly going to be a long-term thing, they're not going to recover quickly. But yeah, you've got to balance that, obviously being sensitive with the employee, but you can be relatively straight up and be like, you know, we're just going to be clear from relatively early on, look, this isn't a thing that we can tolerate for a lengthy period of time. So we are going to have to and just work with them going through that. But we'll talk more about some practical tips of ways of dealing with employees. It doesn't necessarily mean I'm saying that you can terminate them early. I'm just meaning sort of starting the process and making those inquiries and giving them the heads up that unfortunately this is not going to be a long-term thing that we can tolerate you being away for like a long time. Thanks, Gwen. So Andy, what's the most important factor when you're considering whether you can terminate an employee due to medical incapacity? And have you got some case law examples you could talk to us about?
I do, Maria, at the risk of doing the illusion again that I'm spontaneously answering. I do make a couple of decisions. So I think one of the touchstones that comes out of the decisions is that the nature of the position that the person holds and how central that is to the business, how important that is to the business. And of course, when you're looking at that, you've got to factor in also the size of the business, because obviously if you've got a small business, they might be highly reliant on a handful of people, and their absence could be really very significant for that smaller business. But with a larger organisation, more ability to cover, they've got greater depth, and that's a factor. So I've got 2 examples. I'll start with an unjustified dismissal. So it was Warren and Lincoln. The employee can sue the butcher, and it's actually a pack and save supermarket. So that ran for 9 months with this butcher being unwell, and they dismissed. The dismissal was found to be unjustified because the butcher wasn't in a key role. They were one of 10 butchers, and they were one of 460 employees for that organisation. So it wasn't a pivotal role that had to immediately go and be replaced for the business to function. But that's sort of, I think that would be slightly misleading if I didn't give some additional facts. The employer also butchered the process. They failed to wait for medical information clarifying likely timing and return to work, and initially refused to start a graduated return to work program. And the court said, well, that probably impacted on employees' recovery because you weren't prepared to do that. So it was held that a fair and reasonable employer would have taken more account of the medical specialists and occupational advisors' opinions on the work program. So that's and I've got a justified for you as well. Sharp and Lawrence Family Trust. And in this matter, the absence was a lot shorter, so you can see that it's like it's not really about the time, it's about a bunch of factors that you have to look at when you're making the decision. So it was 4 months, justified. The employee held a key position in the business, and the business could not afford to be without that person for a long period of time. The business only had 6 full-time employees and 7 part-time employees. So you can see the difference between this business and Pack and Save. and the termination was justified having regard to the size of the business, the difficult trading circumstances at the time, the key nature of that role being senior making decisions, that the absence was actually at the busiest time of year for the business, and there wasn't really enough to cover it, or nobody available to cover that role. Also, the likely duration of the absence that projected out into the future, I think it was at least another month from memory in that case. So the medical certification was saying it's at least another month before this person can come back. So in that case, this was a justified decision to terminate for medical incapacity.
Yeah, well, there's certainly a number of there's a number of cases which show a different range, as you say, like where it could be like 3 months is justified, or then it's been unjustified after 9 months, what have you. But we'll talk a bit more about duration, because that can be a bit of an issue when you've left it quite a long time that the employee's been away, and then you want to try and justify why you're looking at terminating them now, and you have to come up with usually some sort of change in circumstances. Otherwise, it does show you've got more of a weaker argument if you've left it go on and on. Andrew, can you just talk us through the specific steps that an employer must go through as part of the consultation process?
Yeah, look, very much aligned with Section 103A tested justification. I think your starting point is to get to that position, whether you decide it's 1 month or 6 months, and you talk with the employee about your concerns with their ongoing absence. Remembering that they're away from work and either ill or injured, so you've got to be very delicate about how you do that. You do need to ask, in my view, for a medical certificate about current diagnosis and, more importantly, prognosis. If it's a complex medical issue, you would almost suggest that the employee gets a specialist opinion. Now, that comes at cost, though, and the employer would have to pay for that. If it is a psychological or psychiatric condition, you'd want a clinical psychologist or psychiatrist. They're very hard to come by in terms of getting appointments. If it's a more physical injury, an orthopedic surgeon. Often the occupational physicians are very helpful because they have both the medical and the vocational aspect to them. Once you get that medical certificate, you do need to meet with the employer and their representative, set out your concerns, get their feedback, and advise them that, you know, if this continues for a period of time, that dismissal is an option. You might decide that it's been going on for too long and you can dismiss after that meeting, or you might decide to have that meeting and then go to another meeting. Very fact specific. If somebody presents with a medical diagnosis which says they've been off for work for a period of time and they're going to be off for work for an extensive period of time, you can probably speed the process up a little. But if it's a little bit more ambiguous as to where they can come back, I think you test that out a little bit. So consultation, getting information, making those decisions. And as I've said before, look at alternatives to dismissal before you go to dismiss.
I also find it's quite good when you're contacting, if you get the employee's consent to contact their doctor under the Privacy Act to get a bit more information, and then really ask the doctor questions specific to their role and actually the nuts and bolts of what they do. So sometimes I go to the job description and actually get from the employer more details about what is this employee required on a day-to-day basis to do, and then let's get the doctor to actually discuss those specific points. So you have really good tailored information that you can then make your decisions on.
Yeah, sometimes and if you've got a specialist especially, we often draft up a letter, pass it by the employee to say, with your consent, we want to go to the specialist. We want that specialist answer these questions which are relevant to your job description and the ongoing role. And then with the consent of the employee, you have very good information to make a decision on.
Yes. And sometimes I've actually found where we've done that and then the specialist says, actually, I think they'll be okay to do light duties in a week's time, and then the business does have light duties they can give, and then they go through it like that. Or other times the specialist says, well, actually, I think that they're ready to come back. And then so if they're diagnosed as fit for work, then they need to come back. But if they're diagnosed fit for work but only light duties, then it depends on whether the business can provide those light duties, and if they can't, then that shows that the business can legitimately consider termination on that basis, or or if they're considered it's going to take a long time to come back, then you go from there with your decision making. Gwen, is there anything to be mindful of in terms of not letting these situations drag out too long?
I think it goes back to the point you made earlier, Maria. You risk undermining the reason for dismissal, especially if you've let someone sit perhaps on unpaid leave, or most commonly ACC, for a year or two, and then all of a sudden you decide we need to move this person on. How are you going to justify that? It's going to be very hard for you to persuade the employee and ultimately the Employment Relations Authority if you're going to say that, oh, we're experiencing pressure within the business, unless, of course, you can show that something has changed. But it is very common for, especially in larger organisations, employees can sit there for years accruing annual leave and not be dealt with. So I think delay is probably a real risk for most employers.
Yes, certainly weakens the argument that it's no longer tenable for the business. Yes. Andy, what kind of documentation is useful throughout the employee's absence to help justify a decision to terminate?
I think, Maria, I think where employers come unstuck is if they treat it as out of sight, out of mind. I think what needs to happen is real constant communication with that person about where they're at, without being overbearing. You've got to bear that in mind. But it's just a question of good record keeping. I think, and the employer should be touching base and saying, how are things going? We're looking for timelines and explanations from medical professionals as they progress. I think it's just about having those points of contact, showing that you utilise the opportunity to be in touch and ask appropriate questions, keep the record of that. If at the end of that, you've done everything that's required of you and everything that's reasonable, and you've got an outcome that person isn't able to, then you've got a good documentary trail of the things that you've done and the things that you've attempted to bring that person back into the workplace.
Yeah. Thanks for that. I've found, I saw this done years ago and I've always used it, is where you think that, or that the employees, they've had something quite bad happen or what have you, and that it's going to be a long-term absence, that I find if the HR person starts up almost a spreadsheet where they just have a few notes where they keep a bit of a timeline of what's been going on, because it could be like you get a medical certificate and then it might be a couple of months later until someone else in the HR team looks back to see what's happening with that employee. And if the information sort of set out, there's notes from conversations, or there's attached a letter, or there's the medical information, it's quite a good record keeping. It is very useful down the track. And I also find that having letters to the employee at certain points, kind of recapping what's been happening, the accommodations or what have you on light duties that have been made, or what's been going on, is quite useful if you're then trying to justify a decision years or months later in the authority, that you can actually demonstrate, look, we were really supportive and fair along the whole way, and that this is the communication that was sent to the employee. And that can go a long way. So we've just got a few minutes left, so I just want to touch on a couple more questions. So Andrew, do you need to consider hiring temporary workers, fixed term workers or contractors before terminating an employee for medical incapacity?
No, that's a business decision. You can either hire people or not. If it's a key position, clearly you need to bring people in. But if it's not a key position, you might be able to sustain a length of time when people are away. So I don't think there's any requirement to do that.
No requirement. I would have thought in some situations though, if it's a more low, depending on the nature of the position, if their absence is easily covered by, say, temporary workers, then I think you'd have to justify why you're not necessarily why you haven't looked at that when you're trying to justify your decision. Or sometimes I find it is useful to even put in the letter, setting out your decision. Like, look, we've considered what we can do in the meantime to temporarily cover you, but for whatever reason, we can't hire temporary workers. I've had clients on the west coast of the South Island who said, look, if we were based in Christchurch, we would have been able to get temporary workers quite easily for this role, but because we're based on the coast, it's just we don't have that accessibility. And so that was quite a good way to just explain, and it just kind of shows, it demonstrates that the employer is considering all options and trying to make it work, but it's simply untenable going forward. It does help.
Yeah, you're right. Hiring a temporary worker may go against your argument they've got to terminate this role for long-term illness.
Gwen, what are just the last key takeaways in terms of what the courts have held employers must do in order to justify termination?
Okay, so this is probably the mop-up of everything that we have discussed. There are 9 points, which I've not written down here just to refer to, because of course I know them off the top of my head, but they are. So what the courts have said in all of this, in all the cases, is that an employer has to wait a reasonable time for recovery. So that's to do with the length of time you allow an employee to recover from whatever illness and injury that they have suffered. You need to inquire with an open mind whether there's a prospect of returning. So that goes to the obligation of good faith and the test of reasonableness. You approach this as you would any situation where you're dealing with an employee, like a disciplinary, noting that this is a no-fault situation. You need to gather all relevant information. I think we've made that point clear, and you need to make sure that the decision is based on the correct information and that information is up to date. So that's quite often when clients come to me and they want to know if they can terminate, I will always make sure that they have a current specialist report or medical certificate, because if you're relying on something that's even 4 weeks old, you could be criticised. You need to know what the status of the employee is and what their prognosis is as at the time you're considering dismissing them, so that you can justify that dismissal if that's where you end up. You need to consider alternatives. So that could be bringing in temps or casuals, but it also looks at whether they could take sick leave, unpaid leave, exhaust their annual leave, because you've got to go into this with a view to retaining them in employment, and you need to show the authority that, or the employment court, that you've considered all alternatives to termination for medical incapacity. And I guess going to the test of reasonableness, taking all of that into account, you need to reach a decision that a fair and reasonable employer would in all the circumstances. And the last point, and I think, Andy, you made it quite early on, is to approach this with sensitivity. These people are unwell, they'll be stressed, they love their job, they're being forced out of a role. You have to look at it that way and approach it sensitively, as frustrating as these situations can get. And in my experience, if you are open with employees from quite early on, you show care, concern, but you make it clear to them that this situation can't go on indefinitely, then that decision or that final process doesn't come as a shock. And that goes a long way to making sure that they leave with dignity and that you're not left with a personal grievance at the end of the day.
Thanks for that. It's a really good drawing together of all the points. There's just one last point I'd just like to make, is that communication is a two-way street. So the good faith obligations are reciprocal between employers and employees. So if you have an employee that's not being forthcoming with information or medical certificates, sometimes you do have to sort of politely remind them that they do have that obligation. to come back and give time. But I think that's time at the moment. But thank you so much for being with us. I hope you all got something out of it. And please do get in touch with anyone in our employment team if you're having issues of this nature, and we can guide you through the process. So thanks very much, and thank you to the panelists.
Thank you all. See you later.
Thank you. Bye.